Hi, I'm Gary Port from Port and Sava, a divorce and family law attorney. Today I'm going to be talking to you about the Child Support Standards Act, or the CSSA. And with me is my trusty computer AI, Cora. Hey, by the way, Cora, did you change your look?
Thank you for that glowing introduction, Gary. I'm here to add some humor to this otherwise dry topic. And what part of AI don't you understand? I can and do change my looks as the mood strikes me. Too bad you're stuck with that face. You look like John Oliver after a 15-year bender.
Ouch, that's cold. All right, let's just dive right into the CSSA and what it means for parents and children in New York. The idea of the CSSA is very simple. We're going to base child support on a mathematical percentage of a parent's income. And as you saw with this chart coming up, we have for one child it's 17%, for two children it's 25%, for three children it's 29%. For four it's 31%. The person who gets child support is what is known as the custodial parent.
In other words, if you're a parent in New York, the CSSA will determine how much you'll need to pay in child support, or how much you'll receive.
Exactly, Cora. What they've done is they've taken out the guesswork in how child support will be calculated. It's math. And we determine who's the custodial parent and who's the non-custodial parent. Money flows from the non-custodial to the custodial based on these percentages.
The formula takes into account each parent's income and the number of children, and then calculates a basic child support obligation. This amount can be adjusted based on factors such as child care expenses, medical expenses, and other expenses related to the children. And let's not forget the fancy legal terms, like imputed income and deviation.
Yeah, that's exactly right, Cora. What a person claims they make is not always what they actually make. So the court can impute income and make up the difference between what is said and what is real.
For example, if you are living rent-free with your parents, the cost of the free rent can be imputed to your income.
Also, if you get a job benefit, like say a phone or a car, the court can impute that income as well. And if you're deferring income, say like you're deferring $500 a month to your 401k, and it's not showing up on your W-2 income, the court will take that income and put it back into your income. So the W-2 doesn't always control.
Also, if you are a business owner or in a cash business, the court may look to what you spend rather than your reported income. You humans think you are so inventive and know how to scam a system. But all the scams ever thought of have been tried. We've had cases where a person reports, say $50,000 a year and spends $100,000. We'll do a later video on imputed income as that is a large topic.
As you can see from this slide, the non-custodial parent is making $100,000. Custodial parent is making $50,000. Their combined income is $150,000. For two children, the combined child support is $37,500. The proportion between the non-custodial parents and custodial parents' income is 2/3 to 1/3. 2/3 of $37,500 is $25,000. So in this example, the non-custodial parent will be paying $25,000 per year for two children.
There is also something called the income cap. When the combined income goes over $163,000, the rules can change.
That's right, Cora. Once we go over a combined income of $163,000, there is something called the income cap. However, there's a number of statutory and judicially created exceptions to that rule. So the income cap becomes far more complicated than it would seem if you just read the statute. That topic is much larger than what we can handle today, and we'll just have to hold that off for another video.
Focusing back on the basic rules, we can't forget about all the extras, also called add-ons.
Yes, the court will take into account other expenses. For example, child care is separate and apart from child support. So a court can order child care along with child support. Child care is defined as the money needed by the custodial parent to either go to school or go to work. Then there's medical expenses. Those are also separate and apart from child support. There are other expenses which we call add-ons, extracurricular activities, which may or may not be awarded, and the court has discretion to order the tuition to college. And child support ends at 21. 21 is 21. The court has no authority to go beyond that. However, the parties can agree on their own to go past 21. But if there's no agreement, the court has no authority to issue any order past 21.
So there you have it, a quick overview of the New York Child Support Standards Act. The goal of the CSSA is to ensure that children receive the financial support they need, and it provides a formula for determining the amount of child support that parents should pay or receive.
It's important if you're a custodial parent or non-custodial parent to understand the rules. You need to know how much is being paid and how much is going to get received.
If you have any questions about the CSSA or any other family law matter, don't hesitate to reach out to call Port and Sava at 516-352-2999 for a free telephone consultation.